Hi, Tim Ash from TTS Real Estate. Welcome to the episode 2 of the TTS Weekly Recap. This is a very short segment where I take up a couple of minutes of your time and run through the top questions that are asked of me from a real estate point of view over the course of the week. This episode, we're going to cover just one topic. I think it's an important one. It's one that comes up very frequently, and it's one that's going to take up the whole video. So I'll run through it with you, and that is, drum roll, pets. Pets. What can you do about pets? The questions I get asked on a regular basis is, as an owner, can I reject a pet? What if I feel my property isn't suitable for a pet? What can I do if a tenant/renter signs a lease and 2 weeks into the lease, they request a pet? What can I do? Do I have the right to say, no, you can't have a pet at the property? What I'm going to do is I'm going to run through the situation, what happens, and then I'll refer to the legislation, and I'll also discuss what VCAT have sort of said for the few cases that have been heard about pets. The reason they've only heard a handful of cases is there's quite a significant backlog at VCAT at the moment. This was due to COVID. To give you an idea, bond and compensation claims, you're roughly waiting between 6 to 9 months. Pet hearings, usually 11 to 12 months. That's how long it would take to make a decision on a pet. VCAT have also implemented a process called on the papers, and what this is to clear the backlog is sometimes they're not even having a hearing, they're just making a decision. So these are the reasons why I'm going to refer to the legislation, because there's a key word which is reasonable. And if you can't prove that it's unreasonable for the pet to be at your property, then it's likely they would probably just make a decision to say that the renter can have the pet at your property. But what I'll do is I'll run through the process. So essentially, if a tenant would like to get a dog at your property, they have to fill out an application form that they get from Consumer Affairs. You as the owner have then 14 days to either accept or reject that application for the tenant to keep the pet. If you decide to reject the application, we then have to make an application to VCAT on the grounds that you feel it's unreasonable for the pet to be kept at your property. There's obviously a fee that's involved in that. We then issue that notice to the tenant, and then the decision gets delegated to VCAT to make. So either way, if VCAT rules in the renter's favour, then there's really not much you can do to prevent the pet from being in your property. That's pretty much the process. Now, what I'll do is I'll run through the legislation and just sort of interpret it as we go along, so you can understand what VCAT would deem as reasonable and not reasonable. So Division 5B covers pets in the Residential Tenancies Act. So under 71C, residential rental provider must not unreasonably refuse consent to keep a pet on the rented premises. So what would be unreasonable? Well, in the cases that VCAT have had on this, just because you don't want to, or you think that the pet's going to damage the property, or you just don't like pets, is not a reasonable request to not have a pet kept at the property. So if those are sort of the reasons that you're thinking of, it's likely that VCAT will rule in the tenant's favour, and they would then be able to have a pet at your property. This is 71D. So application to refuse consent to keep a pet on rented premises or exclude a pet from rented premises, a residential provider may apply to the tribunal for an order that is reasonable for the rental provider to refuse to keep a pet on the premises. So bear in mind that you can apply to VCAT, and technically the tenant isn't meant to get a pet until VCAT have that hearing. Under 71D Section 2, a residential rental provider who reasonably believes that a renter is keeping a pet on the rented premises without consent may apply to the tribunal order to exclude the pet from the rented premises. So the only thing you can apply for in this instance is to exclude the pet. You can't really go for possession, even if they sign that they would ask for permission in their lease agreement to get a pet. It's not grounds to ask for possession and kick them out. The best you can do is, if you can prove that the property is not reasonable, prove that it would be unreasonable at your property for the renter to have a pet, you can get the pet excluded from the lease. Tribunal orders. So obviously this means that VCAT can basically, once the hearing is held, VCAT can do one of two things. They can approve the pet or they can reject the pet. There hasn't been a case, unfortunately, where VCAT have rejected the pet. There's been, as I said, a handful, and every single time VCAT have ruled in the renter's favour to keep a pet at the rented premises. The reasons that they state that that they would rule against you having a pet at the rented premises are the following: whether the character and nature of the rented premises isn't friendly for pets, the character and nature of the appliances, fixtures and fittings on the rented premises, whether refusing consent to keep a pet on the rented premises is permitted under any act. So this would be, say, keeping a farm animal, an alpaca, at a residential rental property. You could apply to VCAT to get that pet removed. Any other reason they deem reasonable, and basically if they make the order, then they have to specify a date as to which the pet is to be removed from the property. So that pretty much sums it up, that what VCAT deemed as unreasonable are really only those dot points that would apply. Another way you could do it is, if you were planning on moving back into the property, and you were allergic to dogs, and you didn't want that odor there, you could possibly say it's unreasonable for the renter to have the pet on the basis I'm moving in at the end of the lease, and it's going to play up with my allergies from that point of view. So that's pretty much the general gist of it. There aren't really too many outs in this situation, because even if they do get a pet without permission, you would still have to apply to VCAT and prove under those 4 reasons why the pet needs to be excluded from the lease. If the pet is causing damage or the property is filthy because of the pet, rather than try and breach the tenant on the basis of the pet doing the wrong thing, you would be better served breaching under damage and also cleanliness, and doing that from a consecutive point of view, and then you can apply for possession should they not comply with the successive 3 breach notices. You can then make an application to VCAT for possession, and that could be damage that they've done, damage that the pet's done. The property could be filthy because of the pet. That would be a more efficient way of doing it, because there's nothing in the legislation that says you can apply for possession on the basis of getting a pet when they shouldn't have. The other out that rental providers have is that when they change the legislation, there used to be a no reason notice for 120 days. Now you can, as long as it's the first lease that the tenant has taken, so they're a new tenant, as an example, they're a new tenant that's moved into the property, they've signed a 12-month lease, you can issue a notice. You have to give them a minimum 90 days notice that you're not going to be renewing the lease at the end of the fixed term tenancy. The consideration with that is, if you issue that notice, say 1 month in, then at any point in time for the duration of the lease, the tenant can then counter with a 14-day notice and not be held to the fixed term of the lease. So essentially you're losing your security in terms of having a longevity type of tenant. They're kind of the ways you would go about it. And I really hope that that clarifies the pet situation. Obviously, we know that the laws do favour the renters in this particular section, but just the way the cookie crumbles. Well, I really hope that you have enjoyed this video and that you've gotten a real lot out of it. I know if you're still watching, thank you. I've taken up 10.5 minutes of your time, but it's been an absolute pleasure. I'll check in with you next week, and hope you guys have a great weekend. Thank you again. Bye.